Mr. Allen.
Yes, sir.
Hold on just a second. Hold on just a second. Let me pull up the file. Is your client here?
I'm sorry. Yes, sir. Miss April Bibbens, she's present, Judge.
Okay, hold on just a second. Hold on. You may proceed.
Have a seat. Okay. Judge, and the state filed a motion to have some handwriting exemplars. I filed a response objecting to it. I've talked to the state, and she'll correct me if I'm wrong. It's not that she wants a copy of my client's signature. She wants to have my client to sign the alleged victims, reproduce that signature for comparison. And
I'm sorry, say that again?
so there's a Harriet out there that the state wants my client to reproduce Harriet's signature rather than her own signature. The state wants her to mimic someone
But she
else's.
wants somebody else to provide a sample.
No,
I'm not following you.
Your Honor, so
This is your motion, so why
Yes, Your
don't you
Honor,
take
thank
the
you.
lead on it?
So this is April Briggs, 24 CF 1962, Taylor Sharpless for the record. I am the Assistant State Attorney who filed this motion to compel the defendant's handwriting sample. Your Honor, the state, upon getting this case, got an FDLE report that did request Ms. Briggs to provide a handwriting specimen where she does 25 naturally written samples of the defendant signing Heather G. Williams's name. And Your Honor, that is.
Oh, so she wants the sample to be a certain letters so they can compare it to.
That's correct, Your Honor.
Okay, and you're okay with providing sample, but you just don't want her to provide that sample.
The providers, yes, sir. I said we don't want her to provide a sample of anything other than her signature.
Okay.
Your Honor,
There's what's the basis for that objection?
Judge, and Judge, we have it on the legal basis of not being forced to give self-incriminating evidence, in the sense that her writing someone else's signature would be testimonial in nature and not
Case law on this?
Judge, and I did do that in
Or a rule or a statute or something from
yeah,
basis?
Judge, and the first one I did on this one was the Florida Rules of Criminal Procedure 3.220B1, where the rule is that you're to provide specimens of his handwriting, or would be her handwriting.
Okay.
And the state is asking for specimens.
I understand that.
Okay.
Okay.
And Judge,
So could the state respond to that? Is there, what's the basis upon, I should ask you, what's the basis that you're making this request?
Your Honor, so
Is that
based
same
on.
rule, you're citing the same rule?
Yes, Your Honor, so based on the request from the Florida Department of Law Enforcement, the state filed this motion to compel Rule 3.220, and it's C1, and that's going to be H, does specifically and very broadly say.
Wait, hold on a second.
Yes, sir.
read along. And you're saying you're quoting from H? What-
Yes, it's
Okay.
paragraph C, subparagraph 1, and then it's
I'm
sub
sorry,
H.
state the
It's paragraph C,
C,
1H.
okay.
And Your Honor, that rule lists the things that must be disclosed to the state after an information is filed against a defendant. And that specifically and very broadly says provide specimens of the defendant's handwriting. Your Honor, the state's argument that this request from the Florida Department of Law Enforcement is valid is that it says the defendant's handwriting. It doesn't say it has to be a signature. It doesn't say it has to be.
Where's the subparagraph that talks about the handwriting?
It's H, Your Honor. It's C1H. And it doesn't even require that it be a signature, although that's what's being requested of the defendant. And it doesn't require that it be the defendant's signature. Your Honor, the reason for this request is because Heather G. Williams' signature, who is the principal of Bruner Middle School, it is the allegedly forged signature, and the analyst has to compare apples to apples.
Well, I understand why you're doing it. He's saying that's right. It might prove his client might be, vulnerable under that, and that she can't self-incriminate.
Well, Your Honor, the statute.
Do you have a statute that says that, or a case law on this?
And I would, Judge, under the issue that is testimonial, and I provided that to the court, is Lacey v. State.
Do you have the case?
Oh, no, sorry, Judge.
Okay, I need the case.
Okay.
I actually have to interpret it if you want me to rely upon it.
Your Honor, the legislature has required this in the statute. That was
What do you
against
mean the legislature has required it?
this, or the rule. This rule has been enacted for quite a while.
No, I understand that. The question is just whether they can specify exactly what the handwriting is. I just need some case law. I need something to interpret. I understand his argument. I don't know that it's an argument. Let's just put it that way. I don't know that I agree with it, but I'm just trying to get some case law that make sure we're clear.
Judge, and I go back to the
Anyway.
rule, and it says.
No.
Okay.
If you want case law, give it to me. Give me a brief. Give me a couple cases and make your argument. You can do it in a letter form. Provide me a proposed order, and I'll deal with it.
Yes, sir.
Okay. I just want to be precise about it.
Your Honor, just for the record, every time we get a request like this from FDLE, it does request what the handwriting sample should be of. So this is not an unusual request.
Okay. Put that in your argument. That's a good argument. I'm just asking if somebody has some case law to support their position. The rule is, I see the argument. I don't know that I agree with it, honestly. I'll tell you the truth, but I'm going to give him a chance to provide the argument if you have, but he doesn't have that here today, nor do you. So, there's a point that's been raised. Give me some case law, I'll make a ruling on it. I won't dawdle.
Yes, sir.
Okay, thank you.
Judge, and you want that within
How long do you need?
10 days?
A week?
Yes, sir.
Give me
That's fine, Your Honor.
a week.
Thank
Okay.
you.
Your Honor, she's set this afternoon for plea day, and a not guilty plea has not been filed yet.
You're going to enter a not guilty plea today?
Yes, sir, and request a trial by jury. And again, Ms. April Biggs is present. Thank you.
So, what number is that? I don't have Mr. Allen's.
I
Set for
didn't know.
Mr. Plea day?
Yeah. Is it set for this afternoon, did you say?
Yes, sir.
What number is that?
I'll show up the docket.
I don't have your name on it.
I did a notice of appearance.
Well, I understand, but it just hadn't caught up with it.
Okay.
I'm not disputing that you're representing, I'm just trying to figure out which.
Number 9,
Okay, very good.
And Your Honor, what date is that being set for? Is that 12/9?
Yes, we'll come back on 12/9 for our standard pretrial.
Thank you, Your Honor.
Thank you.
Ms. Graham? Ms. Graham, she run off?
I think she's in the hallway, Your Honor,
Okay.
waiting to talk to her client.
Mr. Patel, you want to come forward? Would you announce, Mr. Patel?
Yes, Judge. Jay Patel on behalf of Timothy Allen Flynn, 17 CF 218 VOP, 24 CF 2114.
Oh, there's some other, I've only got the one.
We're going to wrap everything up.
That's all right.
With the plea, Judge.
Okay, that's good. I just didn't have it on my.
I understand. Have you sign it? Let's get you. That's what we talked about. Summation, there's $200 in court costs for the VIP, 120 days to pay that, plus whatever restitution is. New case, misdemeanor, restitution, $270 in court costs, paid in 120 days. All right, Judge. Jay Patel on behalf of Timothy Allen Flynn. We're resolving two cases today. One is 17 CF 218. This is a VOP, and 24 CF 2114. The understanding is that my client will admit and plea no contest. The admission to 17 CF 218, probation will be revoked and terminated. There'll be a $100 VOP, $100 cost of prosecution. All fines and court costs and any outstanding restitution to Walmart shall be payable within 120 days. Thereafter, convert to civil lien. On the new case, 24 CF 2114, he will plead no contest to the lesser included offense of petty theft. The understanding is that he will be adjudicated guilty. It will be $494 in restitution to Walmart, $270 in court costs payable within 120 days. Thereafter, convert to civil lien. Okaloosa County Jail, credit for time served. The only issue, I have a check from my law firm for the $494. I have not filled out the pay to the order of. I haven't done this in a while, so is it to the Okaloosa County Clerk of Court?
I would just walk down there and then they probably can give you some direction, unless, Madam Clerk.
we have to have the victim information specifically so we can enter it in, and then we cut the check to the victim, and then there's a $3 restitution fee on top of that.
Okay, so I can handle all that downstairs?
Yes.
Okay,
Do you have an agreement, plea agreement?
I do. I'm just going to get him to sign it real quick.
Sure.
Your Honor, that is the state's agreement.
Okay, thank you.
This is not a downward departure. The state will submit a score sheet.
Very good, thank you. Is the lesser included a felony?
Actually, Your Honor, there's no score sheet needed now that I think of it. It's not.
Okay. You may. Thank you. Mr. Flynn, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God? So, Mr. Flynn, you heard your attorney state the terms of your plea agreement, and those same terms are contained In the written plea agreement, I'm just checking to make sure you signed, I know you did, but. Hiding up here. Very good. So the plea agreement you've signed, just want to make sure, if you read this closely and gone over it in detail with your attorney?
Yes, sir.
You understand that by entering this plea agreement here today, this will be a final resolution of both your cases. You're waiving the right to go to a trial and some other valuable legal rights. You understand that you've gone over, it, gotten all those questions answered by your attorney, and you're entering this freely and voluntarily?
I am.
Very good. Based upon that, the court will accept your plea agreement, and the court will sentence you as follows in 2017 CF 218, which is the VOP. There'll be an admission of the violation of probation, or the underlying charges on the VOP, have they been admitted to, as far as, are they guilty? There's been admission of guilt?
I believe so. He's a convicted felon, so.
Well, I understand, but as it relates to this, we have to determine whether, if we're resolving, we have to determine whether there's a guilty plea or what the withhold of adjudication on the underlying VOP. I assume that it's guilty plea, it's just not contained in the plea agreement.
Did you respond to these? You seen it last night? I don't know.
I'm looking at it.
I do have some orders. How do I know what they are? I gotta write them up.
Your Honor, from the clerk's side, it's shown the previous adjudication of guilt.
Okay, so they were previously adjudicated, the defendant was previously adjudicated guilty on the underlying charges in the VOP, and probation is revoked and terminated, and the court will assess the standard court costs, the $100 court costs, violation of probation fee, all fines, court costs, and outstanding restitution to Walmart would be payable within 120 days. Is there restitution on the VOP as well as the other charge? Because you then talk about the restitution on the new charge.
Yeah, I think that the majority of it has been satisfied, but,
There might be a little bit on both
That's right.
cases. Okay. So anything on 218, the case number ending 218, anything payable to Walmart would be payable within 120 days. After that, it would go to a civil lien. In 24 CF 2114, there'll be a lesser included charge of petty theft. Do we have a statutory, we need a statutory cite for the clerk on the lesser included,
I'll get that right now, Your Honor.
okay? And while you're looking for that, the restitution to Walmart on that case is $494, and $270 in court costs payable, again, within 120 days. Thereafter, it would go on to a civil lien. And in that case, the technical sentence is credit for time served in the county jail. Okay?
The statutory site is 812.014-2E.
That's the lesser included. Okay?
And can you specify which Walmart, so I can go ahead and enter the restitution, so Mr. Patel can pay? Which Walmart? The
Oh, I'll
address?
tell you right now.
Is it the Beal or Destin?
I'm checking right now, one second.
Destin.
Yes.
Okay, the restitution information is in there, so you should be able to.
Thank you.
And even though you've just entered this agreement, you do have 30 days to appeal. Thank you.
Thank you, Judge. Maybe
Thank
excused.
you, Mr. Patel, you're good. Counsel?
Morning, Your Honor.
Good morning.
Brady Merrifield on behalf of Joseph Bennison, you'll find that it's listed under Flaherty in 23 CF 2171. No, it's
Okay,
Bennison.
got it, thank you.
Thank you, Judge. And as the court may recall, Mr. Bennison had previously entered the plea and sentencing agreement on August the 19th. He was scheduled to go to DOC on the 17th of September, but the court was gracious to allow him extra time to have that surgery. We do thank the court. He did have the surgery. He is now physically able, so he is here today to begin his DOC sentence. We did have the score sheet when we last appeared before the court, but it was not placed into the court file. We wanted to wait until today to do so. I have the score sheet, which, Judge, you have previously signed, and also a copy of the plea, if I may approach.
You may. Thank you very much. I've already signed it. Did I sign it?
You did, Judge. You handed it back to me to hold on to for sentencing.
So, you want me to re-announce the
If you would,
sentence?
Judge.
So, the court will reiterate the plea and sentencing agreement and sentence you here today on but case number 23 CF 2171 as to count 1. There'll be $615 in court costs. The court is sentencing the defendant to 20.475 months, Department of Corrections. You will get credit for all time served on this. On count 2, the exact same amount of months in the Department of Corrections with credit for time served. These will run concurrent. All these will run together, but they're independent of one another as well. Count 3, again, sentenced to 20.475 months, Department of Corrections, with credit for time served, concurrent with counts 1 and 2. And count 4 is a misdemeanor, and therefore the sentence is 11 months, 29 days in the county jail. Again, you will get credit for all time served, and you'll be concurrent with counts 1, 2, and 3. The state, in this case, is withdrawing the intent to seek habitual felony status on this case, and all counts and cases run together and will be, again, the identical 20.475 months, Department of Corrections. Any of the cost and fees on this will be payable within 120 days following release, and after that, it'll go to collections. Okay?
Thank
Any
you.
question, anything? Did we get all of them?
We did, Judge. Thank you.
That was the state's agreement.
Okay, thank you very much.
Cameron brought this to my attention this morning, and so Jessica, when she said it was one that was actually her.
Judge, the next case I have is an inmate,
Okay.
Brent Bucker. Should also be
Is it-
listed under Flaherty.
Yeah, it's not on, this one's not.
It was, Judge, you just signed the order relieving the public defender, I believe, yesterday. So
Who
your
was the
docket-
public defender, do you know? Which one? It's under the,
I think it may have been Mr.
what's the name again?
Bucker.
I think it was Mr.
Yes,
Buringer.
yes, that was my client apparently.
Okay,
Thank you, Mr. Medina.
I'll find it.
Mr. Brent Bucker is present in 23 CF 491. It is a violation of probation. This is the first time up. I did provide a written notice of denial. I am still waiting on some discovery. I have consulted with the state on this. Judge, we're exploring some treatment options, so we'd like to set it for the next VOP date so that I can receive all of that information from the state and see what options we have to get some treatment.
Very good. Come back November 14th,
Thank you, Judge.
9 a.m.
And I believe that's all I have, Judge.
Thank you very much. Ms. Graham, you want to go, or if you're still, we're ready.
we'll continue to.
Continue until 11/14. How many do we have on that? 11/14, we only have one that month.
Good morning, Your Honor.
Graham, I need to make sure, I don't have one under your name, so.
It was a late, updated docket.
Is this an add-on, or is this on another?
It's not on the
What was it under? I just gotta figure out, because it goes by attorney's name.
It actually was an add-on, Your Honor.
It was an add-on? Okay. Just go ahead and announce it. and we'll-
Yes, Your Honor. This is Trisha Graham on behalf of Darius Wilson. It's set for status today on 22 CF 189. He, however, has multiple cases, Your Honor. This case is being passed around to different attorneys. He wasn't on the docket. It's been through Mr. Losco and Giordana, now Ms. Bossow, which I've been in communication with each of the attorneys, as well as Mr. Wilson. It's a complicated matter with a violation of probation. The original sentences underlying plea involve a suspended sentence. So we're trying to figure this out given the nature of what the violations were and what would be reasonable for a resolution. He has been sitting in jail for quite some time. He's looking at credit for that time. We do not have a final resolution yet. I did receive a new offer yesterday from Ms. Bossow, and I believe Ms. Giordano is covering for her today.
That's correct.
There's still more things I'd like to tweak and for him to be able to consider and have it on paper. She's to provide a score sheet and a written for him to discuss that.
Let me ask you, we still have, what do we have on October 22nd? Can you do it as that soon? So we have, the next 2 days are October 22nd, which is next week, obviously. And then the next one isn't until November 14th.
We'd like to do it soon. So you're looking at
Can you do it next week? Well, if
October
it's that fast.
22nd?
I don't want to presume you can get all
Right.
your,
I'd like to
Ducks in
at
a-
least have it on your docket, Your Honor, so we can have the paperwork and for him to, if not, we may want to address a bond at this point. I know he's anxious to have some sort of resolution.
okay, well, that's why I'm trying to do it as fast as possible, so.
And that's-
We'll continue, we'll just put it on there, and then, obviously, if it can't be resolved, we're not going to a hearing on that date, so.
Right.
Hopefully, we can get some resolution.
I at least have a final offer. It's still in
Sure.
flux, so that would be
We'll
appreciated.
continue it till, again, October 22nd.
If I just may have a moment with him to make sure.
Sure?
And Your Honor, a notice of hearing was only filed in one case, however, he has numerous pending cases. Can we clarify that all his pending cases should be set on the 22nd?
All the pending cases should be sent on the 22nd. You didn't list them all, because
Nope,
it's
I have
only
a
listed
list.
on one, but
Do you want me to list them right now?
I've got it on the motion, just the notice of hearing only
Got
lists
it.
one case.
we'll track them all his cases on October 22nd.
There should be 7 cases, what I'm tracking.
Yes.
Okay, good.
All right, that concludes it. So we have October 22nd. I'm sorry, what time was
9
that?
a.m.
Thank you, Your Honor.
Thank you very much. Who got here first, Mr. Madden or Mr. Durrell? Mr. Durrell.
Thank you, Your Honor. Good morning.
Good morning.
May it please the court, Dustin Durrell, Your Honor, I'm here on behalf of Ms. Chaplain Gerhardstein. She is an inmate.
I'll go find her on the docket.
Is she coming up?
Yes, sir.
There's so many different dockets. We gotta update every single. do too. Yeah, because now I don't have.
Your Honor, I've been discussing with the state a potential resolution to this matter, the violation of probation and new law together. There's just one or two specifics we need to iron out. If we could have the next available court date, I believe this will come in for a plea. Did I hear you say
October
next week?
22nd would be
Works great, Your
preferable,
Honor.
because we only have, just so everyone understands, we only have one miscellaneous day in November. So we want to try and actually get some more on the one next week, so it doesn't just completely overwhelm us in November.
Yes,
So
Your Honor.
October 22nd?
Yes, Your Honor, that would be
We'll continue
fantastic.
that October 22nd. It'll be again at 9 o'clock.
Thank you very much, Your Honor.
Thank you.
I believe that's all I have.
You may be excused. Mr. Madden?
Good morning, Your Honor.
Good morning, Mr. Madden.
John Madden here on behalf of Catherine Day. Your Honor, we have,
Go ahead and announce both cases.
her cases for this morning's docket, it's 23 CF 2848 and I believe 28 MM 4307 are both on the docket for this
I
morning.
think the 23 MM 4307.
I'm sorry, you're right, Your Honor, 40 MM 4307. Judge, she's also got a new law charge from case number 24 CF 2172. I've spoken to the state and to Ms. Day, and we've come to an agreement to resolve all pending cases for Ms. Day. And so we've discussed the plea. It's been signed by myself and Mr. Sprouse. I just need Ms. Day to sign it, and I'll bring it up to Your Honor.
And the new law charge, has there already been an arraignment on that?
I believe it's been waived, Your Honor. I think we waived the arraignment, entered a plea, and not guilty at that time.
Okay,
So we'd
very
be
good. That's fine.
withdrawing that plea and tendering a plea of no contest. If I may approach.
You may. Thank you. Would you announce the plea, sir?
Yes, Your Honor. And just for the record, Your Honor, the new law case is very new. We have not received discovery on that case yet. I've discussed that with Ms. Day, and that there would have been, there could have been the potential for
Sure.
motions or to try it or have the state prove their case. She understands all that. She has decided that this is in her best interest to go ahead and enter a plea to resolve all cases here this morning, but I just wanted it on the record. That is a discussion I had with her.
No, that's good. Thank you for doing that.
So on the new law charge, it's going to be a withhold of adjudication. It's going to be 12 months of drug offender probation. There's going to be fines and costs, and unfortunately, I did not know what that would be for possession of controlled substance.
6:15.
615?
615.
Okay, I'll put that in there.
Okay.
And then $100 cost of prosecution.
Okay. It says 50, I'm going to put 100.
I'm sorry, 15. My apologies, Your Honor.
Okay.
And then on the two violation of probation cases, her probation in those cases will be revoked and terminated.
Okay. Are there any fees on those two?
I believe there may be, Your Honor. I would just ask that she have the term for new probation to pay those off.
Okay.
Anything that was outstanding.
And that is the state's agreement, Judge.
Do you need to put that in there, that they all the fees and costs should be?
Yeah, let me write that.
Yeah. Just, we can get a verification of the costs if we need to from the clerk.
There'd be a $100 VOP fee in 23 CF 2848 and a $50 VOP fee in 23 MM 4307.
Yes, ma'am.
Excuse me, Heather Keene with state probation.
Yes, ma'am.
If she's going to be on drug offender probation, is that going to include a curfew as well as drug testing?
Good question.
Yes, ma'am, and I've explained that to Ms. Day, that those would be conditions.
So we just need to know the time frame for the curfew.
Yeah, put the, what's the standard?
The standard is 10 to 6, but a lot of judges do 7 to 7 and
Right.
adjust it for work purposes if she has a job.
We would ask 7 to 7, Your Honor,
That's
and then
fine.
the ability to adjust for work purposes.
And put that in there as well, in the plea agreement. Thank you.
Yes, sir.
All right, may approach.
Sure. Thank you. That's all right. I'm used to bad handwriting by our lawyers.
I prefer to type things, but sometimes you just.
No, and I appreciate the typing when you can. Okay, so you heard your attorney state the terms of the plea agreement, and I see those same terms. We've had a little bit of a discussion after the fact, after you've signed it, so I want to make sure you understand that the new probation on the new law charge, 1-year drug offender probation, is going to come with it with a curfew, 7 p.m. to 7 a.m. You can change that if you have work, you have an evening shift or something, but you got to coordinate. Whole key is you know on this probation is staying in contact. Okay, and a little higher level of supervision on drug offender. You understand that?
Yes, sir.
You willing to do that? We want you to be successful, but you got to pay attention to this because you now have a violation on your record. So if you get another violation, they may be coming back asking for jail time. So you want to sign it, we want to get out and get moving, but you got to pay attention to this. You willing to do that? We want you to be successful here. Can you do this?
Yes, sir.
Okay. And you understand that by entering this plea agreement, you're waiving the right to go to a hearing, a final hearing, a trial, or a hearing on the VOP in order to resolve this? You believe it's in your best interest to enter this plea agreement, even though the new law charge, as your attorney said, you haven't even gotten discovery on it. But you understand what happened, so you believe it's in your best interest to enter this plea agreement here today and not wait around for a discovery and all that?
Yes, sir.
Okay. Do you have any other questions regarding this?
No, sir.
Okay. Very good. Based upon that, then the court will accept the plea agreement. As to, one thing on counts both 1 and 2 in 24 CF 2172, there'll be a withhold of adjudication. That's important. Then you're not going to be a convicted felon. That's another reason why you want to stay on this, because the first thing they're going to do, if you violate, they're going to try and force you to do an adjudication of guilt, right? Now you'll be a convicted felon. That carries a whole nother set of circumstances. Again, stay on top of this. So you have withhold of adjudication, and the court sentencing you to 1 year of drug offender probation with a curfew of 7 p.m. to 7 a.m., which can be adjusted for work purposes. Standard court costs of $615 and $100 cost of prosecution. The other two, which are your probation, 23 CF 2848 and 23 MM, the misdemeanor 4307. Both of those is revoke and terminate probation, but there are VOP fees. Those are going to be rolled over into the other one that you have to pay during that year. Okay? Any question?
No, sir.
Okay. Good luck, man.
That's all I have, Your Honor.
Thank you, Mr.
Excused.
Mann. Yes, sir. Have a good day. Mr. Harper, what do you say? You want to?
I've got a couple all minor things. I'm ready to go.
Yeah, let's just, either way.
It doesn't matter, whoever you want. I've got Hammerstrom, Holcomb, and Bibbens.
Humphreys.
I'll address Malik. Yeah, I'll address Malik. Mr. Cobb is appointed.
Yeah, 21, 22, and 41. That's what we got that. I swear. Call his name first.
Judge, this is Mr. Hammerstrom. Rudy Harper on behalf of Bob Hammerstrom before the court on 23 CF 1507. Is this still what you want to do?
Yes, sir.
Sign and date there.
And that's credit for the time from
You
the
get credit for all
Penn
time,
State.
sir.
Yep.
1017. Judge, on behalf of Mr. Hammerstrom, he's going to withdraw his previous denial if he's entered one and admit the violation of probation today. There will be an adjudication of guilt, 6 months in the Okaloosa County Jail on counts 1 and 2, credit for all time served, to run concurrent, revoke and terminate supervision, cost the judgment, credit for all time served as to count 3, which is a second-degree misdemeanor. I believe that the state will follow a score sheet later. This is not a downward departure. He does not.
That's
What are you
correct.
doing on count 3? I'm sorry.
This is a counsel.
Okay.
That is the state's agreement. We will see the score sheet shortly, and this is not a downward departure.
And so the 2 counts are, the 2 incarcerative counts are both concurrent?
Yes, Judge.
Okay. Mr. Hammerstrom, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement. I see those same terms are in writing.
I did,
You've
yes.
signed them. Have you read this closely, gone over it in detail with your attorney?
Yes, sir.
You can put your hand down. I just want to make sure you understand what you're doing, because by entering this, you're waiving some valuable legal rights, and the big one is the right to go to a trial, force the state to prove their case. You believe that's in your best interest to resolve this here today, which is what this plea agreement will do?
I do, Your Honor. Yes,
Do you
sir.
have any questions regarding this plea agreement further?
One question,
Well, ask your attorney. I don't mind answering it, but I don't want you to say anything that might impact your case.
Yeah,
okay,
or just plea out.
okay.
He's asking for a separate misdemeanor case that's pending in front of
Okay,
the county.
yeah, we're not dealing at all, if there's another case out there, we're just dealing with this one violation of probation with the 3 counts on it.
I have 2 VOPs. I have one that's a,
If I may,
Sure. Is there any other cases that have been filed, there's a misdemeanor or another VOP for this gentleman?
Yes, he has a misdemeanor possession of paraphernalia, which is scheduled for November 4th.
Okay, but no other VOP?
No.
There's one other misdemeanor on file, which you're aware of, but there is no other VOP other than this one.
I think the confusion stems from the fact that he believed that there are two separate independent bases for the violation of probation.
Sure.
So that was his confusion.
Okay, very good. So this is case number 23 CF 1507. It's the violation on that case, and there's 3 counts: 2, possession of paraphernalia. Well, no, what is it? Possession of
Of a controlled substance.
yeah, possession of controlled substance and marijuana. So, and then leaving the scene of an accident. So, with this, the court will accept your plea agreement based upon your testimony. There'll be an adjudication of guilt on all 3 counts. As to the 2 possession counts, the court is sentencing you to 6 months in the Okaloosa County Jail. They'll be served concurrently, and you will get credit for all time served on that, okay?
Yes, sir.
And as it relates, on these, all of these, there'll be a revoke and terminate probation. So probation on this case, done. Again, misdemeanor, we're not touching that. We don't know what's going on over there.
Understood.
But for this one, we're terminating supervision. All the costs will go to judgment, and you will get the sentence on number 3, count number 3, which is a misdemeanor. That's just, technically, the term is credit for time served.
Okay.
So you're done with that as well. So you got the 6 months basically with credit for time served on the other 2, and they'll be served at the same time. That's what it means by concurrent. Any
Understood.
questions?
No, sir.
Okay, good luck.
Your Honor,
Do we need to do a score sheet?
The state will provide that later.
Your Honor, the state will submit a score sheet.
Okay, thank you. Madam Clerk?
there was an amended warrant submitted that is still active that has not been served on him. So would you like to recall it
What is the warrant for?
for this case?
Yes. Withdraw the warrant.
Yes, please. Thank you, Madam Clerk.
Thank you.
Judge, this is Jonathan Holcomb. He's before the court on 24 CF 958 and 23 CF 355. Judge, at this point, he's going to admit the violation of probation. If I may have him sign first. Is this what you want to do? Yes, sir. Okay. Sign and date there. It's 10/17/24. He's going to admit the violation, and this is going to be a modification of the supervision to convert the balance of supervision to community control. You'll have bars to bed Phoenix House. The condition of probation will be to complete Phoenix House and all aftercare, as well as complete all other outstanding requirements that were on supervision. $50 VOP fee, $50 cost of prosecution, $150 cost of defense. In 23 CF 355 count 2, which is a first-degree misdemeanor, he'll be sentenced to time served and adjudicated guilty. You may approach, Judge.
You may.
Since this is a modification, there is no score sheet.
State?
That is the state's agreement, Your Honor.
Okay, Mr. Holcomb, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir, I do.
So you heard your attorney state the terms of your plea agreement, and those same terms are in writing, and you've signed that. So just want to make sure, have you read your plea agreement closely, gone over it in detail with your attorney? Make sure you had all your legal questions answered.
Yes, sir, I do.
You understand that by entering this agreement, you're waiving the right to go to a hearing on this and to further contest. This will be a final resolution here today.
Exactly, yes, sir.
Okay, and you have had all your legal questions answered?
Yes, sir.
Okay. Based upon that testimony, the court will accept your plea agreement. There'll be a modification of supervision to convert the balance of the supervision or the probation to community control. As a condition of that probation, there'll be a bars to bed Phoenix House program, which you must complete the Phoenix House and all other aftercare and complete other outstanding requirements of the probation, or in this case now community control. In addition, there's a VOP fee of $50 in cost of prosecution and cost of defense. And in the second case, which is 23 CF 355, You will get credit for all time served as to count 2. Okay. What are we doing on count 1, counsel?
Count one would just be the modification, Judge, in Phoenix House. The balance will be converted to community control. I think that count is the kidnapping charge.
Right.
battery.
Oh,
It was down, yeah.
So basically, both cases are going to be converted to community control. There, you're just pulling out the one count 2, and that's credit for time served. That's going to be finished.
yes, sir. I think jurisdictionally, I think he's
done.
in excess of that time. So.
Okay. So you understand that?
Yes, sir, I
So
do.
community control. Now, community control, higher degree of, I don't like the term community control. I like the term house arrest. That's a better description. That's basically, no curfew unless you're working or something. It's not like probation where you can go, you just gotta come back. You house arrest unless you're doing something. So you clear about this?
Yes, sir, I do.
Okay, very good. Good luck.
Thank you so much. Thank you.
The last one, Judge, is Avery Bibbens.
He's not upstairs because they were full,
Got it.
and he was initially listed as a PD client, so.
Roger. I'll just stand by until he's addressed.
Okay.
He's taking some downstairs to bring the rest of them up.
Okay. Who's are you bringing up? Which attorney?
Do you have it marked here?
Mr. Harper,
They're bringing the rest of yours up, Mr. Harper.
Yes, sir.
initially on the docket, it was listed as a PD client, so it was further down the list.
I
Okay.
was appointed yesterday.
Which one is that?
Bibbins,
Bibbin?
Yeah, I did say let's start with the one over there. That's fine. They just marked this case.
Mr. Harper, you have to pronounce the middle name of your client in order to proceed forward.
I'm not certain I can comply with that order, Judge.
That may be the most difficult middle name.
I don't know. Who are you talking
Oh, I see
Who are
it.
you talking about?
This one.
His middle name is.
Oh,
So you have one, were you stationed in Hawaii, JT?
It's Aloha Mik Humphrey.
Aloha, Keakau.
Very good.
Kia.
I forget we have people here that actually were stationed over there.
I went there on vacation. There you go. Stayed at Holiday Inn Express. Is there any out custody?
Yeah, I was gonna ask, while Frank is switching, if he
Yeah.
had any out of custody.
Any out of custody? Mr. Gates?
Yes, Your Honor, I do.
Okay.
Patrick Hart, Your Honor.
Okay,
Mr. Hart should be number 26 on the docket.
thank you.
The plea agreement we filed on Mr. Hart's cases, Your Honor. It incorporates the two cases before the court today, as well as a new law violation, which is 24 CF 2260. That is actually scheduled for November the 14th, which should take one more case off that docket.
Okay, thank you. Thank you.
Thank you, Your Honor.
Would you announce the terms, please?
Yes, Your Honor. Mr. Hart will be admitting the violations in 23 CF 1058, 24 CF 827. Plea is charged in 24 CF 2260. Adjudication of guilt, all counts and cases. In 23 CF 1058, modify and reinstate probation. Next 6 months will be on community control, followed by the balance of probation. All supervision is going to be concurrent with 24 CF 827 and 24 CF 2260. Complete original requirements, $100 cost of prosecution, $150 public defender fee. And 24 CF 827, same terms, modify and reinstate. Next 6 months on community control, followed by the balance of probation. Supervision is concurrent with 23 CF 1058 and 24 CF 2260. Complete original terms, $100 cost of prosecution, $100 public defender fee. And then violating 24 CF 2260, 6 months of community control followed by 12 months of probation. Again, supervision is concurrent with the other 2 cases. Waive the cost of supervision, standard court costs, public defender fee, and Mr. Hart's entering the plea without the opportunity to review discovery in that case.
State.
That's the state's agreement, Your Honor, and the state will submit a score sheet in 24 CF 2260, which is not a downward departure.
Very good. Thank you very much. Mr. Hart, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
So, Mr. Hart, you heard your attorney state the terms of your plea agreement, and I see that you have, let me confirm, you've signed the plea agreement?
Yes.
So have you read this closely and gone over it in detail with your attorney? Make sure you had all your legal questions answered?
Yes.
You understand that by entering into this plea agreement, it'll be a final resolution of all your cases, okay, here today. All the violations of probation and the new law charge, okay?
Yes.
You're waiving the right to go, in order to get it, you gotta waive the right to go to a final hearing and some other constitutional rights that you're waiving.
Yes.
Have you gone over those? You comfortable that's in your best interest?
Yes.
And you're entering this freely and voluntarily?
Yes.
Okay. Based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt on all counts. In 23 CF 1058, court will modify and reinstate probation. So you're going to basically keep the same term of the probation. That's why it says modify and reinstate. So we're not lengthening it, okay?
Right.
But for the next 6 months, you're going on a community control, which is a higher level of supervision, followed by the balance in regular probation. And all the supervisions, all the probation, all of these 3 counts are all running together. They're running concurrent, okay? You must complete the original terms and then standard cost and prosecution and public defender fee. In the other VOP, identical terms. In 24 CF 827, reinstate and modify, next 6 months on community control, followed by the balance on probation, concurrent with the other cases. Standard fees and costs. In the new law charge, 24 CF 2260, it's a new 6 months of community control, followed by 12 months. So it's a total of 18 months probation. Again, all supervision is concurrent with the other 2 cases as well. Waive the cost of supervision in this case, all cost and standard cost and fees, and you are acknowledging that you're entering a plea without the opportunity to go over discovery. You believe that's in your best interest?
Yes.
Okay. Any questions?
No.
Okay. Thank you very much. Which one? Bibbens?
Judge, I think this is Avery Bibbens.
Okay, hold on just a second. Let me get Mr. Bibbens up. Okay.
No. Judge, Rudy Hartman on behalf of Avery Bibbens, he's before the court on 23 CF 2702. At this point, I would like to enter a denial on this particular case. He has a new law case, 24 CF 2291, in which I was also recently appointed in that case.
That's not real.
I know, this is your view.
Has that already been arraigned? What is it, 24 CF 2291?
24 CF 2291, yes, sir.
Has that been arraigned? Or has there been an information even filed in? Anybody can jump in.
Your Honor, I checked that case and no, there has not been. It's not.
Not an information,
No, Your
an
Honor.
information has not been filed yet?
That's correct. The
Okay.
information has not been filed. It doesn't go to arraignment until November.
Okay.
No, that's not you, that's someone else.
Oh, okay.
So that's on a different docket.
Okay.
Okay? So,
Okay.
So we'll enter a denial today, and if we can track this with his new law violation and set this for December the 11th.
Okay, what's the next, is it an arraignment date?
It would be,
Or you want to just do a pretrial?
and that guilty plea's already been filed, even though information hasn't been filed, but it's currently set for, it would be December 11th.
Okay, so we'll continue this case until December 11th as well. They'll run them together.
All right, so when's the next court date?
December 11th. Thank you, Judge, that's all I have.
Thank you. We'll just keep going and we'll see if he shows
Your
up.
Honor, we received an email from Mr. Cobb yesterday because Mr. Harper's office notified him that he was recently appointed to Humphrey's case.
Right?
Mr. Cobb advised that he has a violation of probation hearing this morning in Santa Rosa County, so he would not be able to make it.
And that's on Mik Humphrey's, Judge. I also contacted him, and he said that he had an evidentiary hearing.
Okay, so what are we doing then with Humphrey? We've got a bond here. So he's been appointed, you're off the case?
Yes, sir.
When was Mr. Cobb appointed? Just-
Yesterday.
Open court.
So if I may, even though I'm not counsel,
Sure.
if we can move this to the next earliest available miscellaneous, maybe.
Yeah, why don't we come back, that's a good point. Why don't, we'll come back, because he's got a new attorney, we've got a hearing next week, date for that, why don't we do that? So we'll come back on October 22nd, 9 a.m. Yeah, we'll bring him out. If you want to bring him out.
Yeah, okay.
Mr. Humphreys, because you're scheduled today for for bond hearings on your cases, let me go ahead and, you've got 5 cases here today, 23 CF 2577, 24 CF 1138, 24 CF 1139, 24 CF 1141, and 24 CF 1795. Because you were just appointed the new counsel yesterday, and he had a conflict today, he let us know. He's over in another courtroom today. So what we're doing is we're continuing this case, but we're going to continue until next week. We'll try and do it quickly. So we'll come back on the 22nd.
Yes, sir.
And we'll hear your case, but you're represented, but he's not here, so we can't
Yes, sir.
proceed without. Can't proceed without. Because you have an attorney, you can't proceed on your own, even if you wanted to.
Yes, sir.
Okay? Okay, thank you. Ms. Farkas, I see on a couple of the cases, I think you may have some out of custody. Why don't we try and get the out of custody so they,
Yes.
if they're
That's what
here,
I
don't know if they're in the court. If they are, let's get them done and get them
Yes.
so they
I
can go
have
on with the
one.
rest of their day.
Yes, I appreciate that.
If you'll-
I think my first
potentially my only present out-of-custody client is Mr. Davis.
Well, I've got a Kane Fuller.
Oh, I didn't know if he was on the morning or something.
Oh,
you're here. Oh, that's great. Okay.
Okay. Well-
I need to speak with Mr. Kane Fuller. There is an offer in his case.
Okay, what about James Culvert? I also have him.
He is not currently present. If we could pass his case, he might.
I'll pass it to the end of the morning, and then I'm gonna,
Thank you.
okay. Do you have, anybody else have any out of custody in the courtroom?
I'm sorry, I have Bobby Davis here,
Okay.
24 CF 2169.
I
He's
don't-
present and approaching.
I don't have a Davis on my docket. Madam Clerk?
6-9.
Do you have a case number?
Oh, it's
20.
set at 1:30.
Oh, well, he's early. Can we handle it now?
Pleading.
Yes. We're entering a plea of not guilty. And it's already set for the 12/9 court date. You're on the 1:30 docket. So, yeah, I think you'll be here. It's at 1:30.
Continue to talk.
Okay, the court will enter a not guilty plea, and we'll come back on 12/9,
Thank you, Your Honor.
pre-trial is your next date.
This is just a copy of the information. So, okay. Thank you, Your Honor, I appreciate it.
Your Honor, I
And I'll
have,
speak with Mr. Kane Fuller now.
I have an agreement worked out for Candice Buringer, and I just need to go over it. We've worked it all out, but I just need to show her the language.
So we don't have any we can do? Let's do pro se inmates. Very good, thank you. Which is the first one?
That's going to be Charles Anderson.
Okay. Well, we'll go through all the no attorneys inmates. Give them plenty of time to work out.
It's fine.
Charles Anderson. Is this your podium, sir?
Would the state announce?
Yes, Your Honor, this is 24 CF 1855. Mr. Anderson is here for a violation today, and the state does have an offer on that violation of probation if the
Okay,
defendant wants to.
Mr. Anderson, begin with, you do have the right with the violation of probation to have legal representation. If you cannot afford one, one will be appointed. You're welcome to listen to the state's offer if you wish, or we can appoint you an attorney, or you can hire a private attorney.
I ain't got one.
You want the court to appoint one? You want me to appoint the public defender?
I ain't saying this is gonna change anything.
I can't answer that.
I don't know that.
What's your offer? What's
Your
the
Honor,
state's offer?
The state's offer is for him to admit the violation, for him to receive credit for time served for the Okaloosa County Jail that he served, and for him to pay the VOP court costs and revoke and terminate supervision. I can write that up if he wants to take that, and we can.
And do you have any questions about that?
Can I ask as a friend of the court question?
It would be an adjudication as well.
Was he
But it's
previously is he already an adjudicated convicted felon?
It's on a misdemeanor.
Oh, it's on a misdemeanor, okay. Just, sorry, judges.
That's all right. That's a very good question.
Where you have these?
Mr. Anderson's getting all kind of help, he doesn't even realize it.
Respectful, I didn't know, can you please say that again? I didn't catch.
So, Your Honor, the state is offering for the defendant to admit the violation. He'll be adjudicated guilty of the offense. He would receive credit for time served and the VOP court costs, and his supervision would be terminated.
So, no more jail time, no more probation on this count. You will get fees and costs and you'll have 120 days to pay them.
So where?
Where?
Yes, sir.
Down at the clerk's office.
Like, here?
Yes, sir.
Yes, okay. As soon as I get out, I got 120 days to pay the fines, or whatever that might be.
Correct.
May I ask, what is the fines?
Yeah, what are the fees and costs?
Your Honor, it's $100 and cost prosecution.
So-
For court costs, it's $420 with our office.
You have some other court costs as well. What are they?
Oh, God.
$420. So the 100 is the new violation of probation.
What a 420 come in at? It don't even matter. It doesn't even matter.
Your Honor, that seems like a financial obligation that was already existing.
Yes.
Okay. So in other words, what happens today?
What happens today? If you accept this, you get out of jail.
Today?
Today.
Oh,
You don't believe me?
Yes, sir.
That's what she just said.
Oh,
Did I miss something,
thinking.
counsel?
Your Honor, that is what the state.
I'm trying not to be, let you know, but
I just woke up,
A
so I'm
credit for
sorry,
time
I'm sorry,
served
sir.
offered
I'm
doesn't
sorry.
result in the
I
defendant
can't
being in jail. That's correct.
suggest to you what you should do.
I
It seems to be fairly obvious, but I don't want to,
Hey,
I'm
I'll
not your
take,
lawyer.
hey, yes, sir, I'll take that.
Okay?
Yes, sir.
You good?
Yes, sir,
Okay,
I'm
she's gonna
good.
write it up and
Yes, sir.
we'll
I'm gonna
hold
write
over. She's gonna write it up so we can go ahead and put it in play, okay? Thank
If you
you.
don't mind.
I'm sorry, I ain't trying to smile, y'all.
Yeah.
Would the state announce the case?
Say the name of the defendant, Judge.
Your Honor, is this Jesse Anderson?
Yes, ma'am.
Okay.
It's case number 23 CF 1127. It's a violation of probation.
Okay. So, Mr. Anderson, you do have the right to have an attorney appointed. This is a new charge, essentially.
Yes,
You have
sir.
the right to have an attorney. If you cannot afford one, one will be appointed. This is state. State sometimes has an offer.
There's no offer at this time, Judge.
Okay.
Your Honor, is this
So-
Jesse Allen Anderson?
Yes, sir.
It is.
I believe that he is already appointed for the afternoon docket on a new law to the public defender, assistant public defender, myself, Stephen Medina. So I would ask that the PD appointed on the VOP to enter denial and hold him over to 1:30, and we can see if we can work it out. Or what was the offer?
He said there is no offer.
There is no offer because from my notes, there's a new law violation. I need to speak with the victim.
We can put it all together, I'll sign something today.
Please don't.
I'm sorry.
Don't say anything.
Your Honor, could the PD be appointed on the VOP, denial be entered, and we can go ahead and waive arraignment because the state's not going to make an offer today, and he doesn't need to be held till 1:30, and then I'll be in to see him, and we'll try to work it out. I guess put him on December 11th, and if we work something out before then, we can bring him up earlier.
There's a copy of his information. Yeah, it is an offer.
So we want to come back December 11th?
I think so, Your Honor. That would be the next pretrial.
That's true.
And I'll give him my
So,
card.
Mr. Anderson, I'm appointing you the public defender, so you get the same. And this afternoon, we're entering a not guilty plea on your behalf, so we can kind of take care of both of these. And we'll come back on the next pretrial, which is 12/11. And if something's worked out in the interim, they'll do that.
Thank you, Your Honor.
Okay, thank you.
Yes, sir, thank you.
case number 24CF1858, State versus Levi Hickman.
Okay. So, Mr. Hickman, you're here today on a violation of probation. This is a new charge essentially, and you do have the right to have legal counsel. But before, sometimes the state will have an offer.
Yes, Judge, the
If
state
you
does
want.
have an offer that they'd like to convey to Mr. Hickman.
You may.
The offer is.
So just listen to this, and if you, when we get through, if you're not wanting to accept that offer, we'll go ahead and appoint you an attorney and give you a chance to talk with them and stuff.
Yes, sir.
Go ahead.
Admit the violation of probation, previously adjudicated guilty, $100 cost of prosecution, revoke and terminate current term of probation, 30 days Okaloosa County Jail with credit for time served, all monetary obligations and any outstanding restitution, 120 days to pay, and which will then convert to a civil lien.
So did you understand that? So you need to slow down a little bit when you're giving this, because you're not a lawyer interpreting it. So you're going to end the probation, but you'll get 30 days jail time. You'll get credit for time served. I don't know how much credit you've got. That's essentially what you're doing. You would accept this, and the violation of probation would then go away. You got some fees and costs, and you have some time to pay those. If you have any questions concerning this, I can appoint you an attorney. You can talk with your attorney before. I'm not trying to press you to accept this. Matter of fact, I want to make sure you're comfortable. If, would this be your client?
It will, Your Honor. I checked the jail website. Mr. Hickman, I believe, was arrested on September the 19th, correct, on the VOP? So, math, he'd be eligible for release, Your Honor.
Okay. Do you understand what he's saying? In other words, it looks like, based on the calculation that he just looked on the website, you've been in for 30 days. And that's what they're offering you is 30 days jail time. You'll get credit for time served.
Yes, sir. I would
Means
like-
you get out.
Yes, sir. I would like to do that, please.
Okay. If what I'm asking you to do is just hang around,
Your
just,
Honor, the state has a plea agreement already drafted.
you anticipated that, huh? Can't imagine why. Okay, she drafted that plea agreement, and you just have to sign it, and she'll make sure and explain it. Thank you, Mr. Gates.
Yes, Your Honor.
Are those the only non-attorneys? No, correct. Okay, so I do have a out of custody ready.
Your Honor, I'm just adding that the time will start from September 19th for this credit.
Okay, very good. Okay. So you're right up against it. It might be a day or two. I don't know. I'm trying to make the calculation. If you were picked up on the 19th, it's the 17th now.
So I'll be at 27 days.
Yeah.
So it was,
You might have a couple more days, but you're almost ready to get out. You may. Okay. So you've had a chance. I just need to ask you a couple questions. Raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
yes, sir.
So you heard the state give you an offer, which is basically 30 days jail, and, revoke and terminate, in other words, end the probation, just do the jail time. But you've been in jail a few days short of 30 days.
Yes, sir.
So with that, you'll get credit for all time served, and there will be all the monetary obligations that are already out there, including any outstanding restitution. You'll have 120 days to pay, and then it'll convert to a civil lien. Do we have the total amount of what is his outstanding fees and costs? They're tacking on $100 on the VOP, so that's in addition to what you already owe, but.
When he was originally sentenced, $420 was
So 420 is outstanding from your original.
Let's see.
So it's 500. And again, pay if you can. You've got 120 days, that's 4 months. If you can, it'll go to lien. They're not going to pick you up and put you in jail or anything, but it could affect your driver's license.
Yes, sir.
Okay?
Yes, sir.
So you're clear, you're wanting to do this?
Yes, sir.
And you're waiving the right to go to a final hearing. You okay with that?
Yes, sir.
Okay. Very good. Court will accept the plea agreement, sentence you to 30 days in the county jail, revoke and terminate, and they'll be previously adjudicated guilty, and any outstanding restitution and obligations, in addition to the $100 VOP, you'll have 120 days to pay, and then it'll go to civil lien.
Yes, sir.
Thank you. Mr. Medina?
Yes, Judge, I have an out of custody. Candice J. Buringer is approaching in 23 CF 1320. Buringer. I'm sorry, Judge, I don't know the
That's all right, I'll get it. I got it. Thank you.
May I approach with the agreement, Your Honor?
You may.
It's a misdemeanor, so there's no score sheet. I'm sorry, I need to make a copy with my phone. And it has been signed. Thank you, Your Honor.
Thank you.
Under the terms of the agreement, this is a misdemeanor VOP that's being resolved with an admission. She was previously adjudicated guilty to a misdemeanor. There'll be a revoke and terminate on the supervision, 20 days Okaloosa County Jail with credit for all time served, and with weekend jail to commence October 25, 2024 at 5 p.m. So next Friday, this weekend, she's got to make arrangements for her elderly mother. So we appreciate the state and the jail accommodating her situation with her mother. $100 VOP fee, $150 public defender fees. And upon completion of the jail, she will have 6 months before the monetary obligations will go to collections.
Okay, just point of clarification when you talk about weekend jail. So I know that it's not starting until October 25th. Are we just doing them, we're not starting and running 20 days from then? We're going to just go weekends?
The way I would anticipate, Judge, is that I've told her that she could probably stay the whole 16 days. She thinks she has about 4 days in. She could probably run it straight from there, but assuming she wants to do it on weekends, it would have to be consecutive weekends. So basically, it would be, 4 or 5 weekends in a row, or 6 or whatever it was, till she served the full 20 with credit for time served. Do I need to add that in there, consecutive weekends, or it's stated on the record?
Well, I mean, you just want to make sure everybody's clear about what weekend jail, what you've got in here is weekend jail. I just want to make sure it's clear for everybody. If it's clear enough for the jail, I'm okay.
I'd be happy to add consecutive weekends, just to be sure, Your Honor.
If the defense wants to do that, that's just the way the jail does the weekends.
Okay. I just want to make sure we're sufficiently clear.
And it doesn't even have to be on weekends, because some people's weekends are different. Because they're
it's just
jobs.
Gotcha. But it's something you'll have to coordinate with the jail, that's the key. It is something that they do, and they accommodate people.
I just put an asterisk, consecutive weekends.
Okay. Very good. Okay, Ms. Buringer, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement, and I see those same terms are written on here, which you've signed. Have you read it and gone over it in detail with your attorney? And you believe this is in your best interest to enter into this? Yes? We're actually recording this, so you got to speak up.
Yes, sir.
And importantly, you're waiving the right to go to a hearing, waiving some other legal rights. And you're entering this freely and voluntarily?
Yes, sir.
Okay. Very good. Based upon that, the court will accept the admission and you were previously adjudicated guilty to the misdemeanor, court will revoke and terminate probation, so you're done with your probation, and you're being sentenced to 20 days in the county jail with credit for all time served, and it will commence on the 25th, October 25th of this year, 2024, which is a week from Friday at 5 p.m. So make sure and get over there in plenty of time so they don't have to chase you down.
Yes, sir.
And you will have the fees, standard fees and costs that are payable within 6 months after you finish your jail, before they go to collections, but you can do your time on weekends as coordinated with the jail, and they would be on consecutive weekends. But basically, you'll have to coordinate with the jail.
Yes, sir.
But you'll start on the 25th, that's the key.
Yes, sir.
5 p.m., okay?
Thank you.
Any questions?
That's it.
Thank you, Your Honor.
Thank you.
Okay. Charles Anderson.
Your Honor, Mr. Charles Anderson is at the podium. He is here on Your Honor's docket 24 CF 1855. The defendant and the state have reached an agreement, which I have written up if the court wants an agreement.
Once you state it first and then bring it up to me,
Yes, sir.
and
And we
I need
both
to ask
do-
you a few questions, just
We
hang
we both do also
Hold on.
need to sign it, Judge. So he, in the 24 CF 1855 case, pled to possession of drug paraphernalia. He has been previously adjudicated of that offense. The defendant would admit the violation of probation in that case. He
So
would-
count one was dismissed?
Yes, that's correct, Your Honor.
Okay.
He would admit the violation of probation in that case. We would add an additional $100 in violation of probation court cost, which the defendant would have 120 days to pay before it went to a lien. He would receive credit for all time served, like I said. Your Honor, the violation is based on, and the state has added to the plea agreement, if the court would accept this agreement, 24 MM 3479, which violated his probation. The charge in that case is trespass, and then a second count of failure to appear. The state would, the state and the defense have agreed that he would plead no contest to the trespass charge. He would receive credit for time served for that. He would pay the court cost, which he would have 120 days to pay, or it would go to us collections. And the state will take no action on the failure to appear in that case. And he would also, again, receive credit for time served.
Very good. If you bring me that plea,
We both do need to sign that, Judge.
okay, go ahead and sign. I'm going to ask you some questions about it to make sure you understand it and you're comfortable with this, okay?
Yes, sir.
But you need to sign it first.
Like, I got paid. All right.
Hold on, so let's take it one step at a time. Go ahead and sign it and then we'll
Yes,
go
sir.
over it.
And Your Honor, I'm sorry, to this plea agreement, I am adding that the court cost in the misdemeanor case will be assessed, but they'll go to a judgment in 120 days if he doesn't pay.
You may. Okay. I need to swear you in. Raise your right hand. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay. So, I just need to ask you a few questions. You can put your hand up.
Oh,
I want to make sure two things. You understand what your agreement is, because you don't have a lawyer here. If you have questions, I'm going to answer them for you. And that you're entering this freely and voluntarily. That's why I'm asking you these questions. So, you heard the attorney, you heard the state attorney state the terms of the plea agreement. You're basically pleading to two separate cases. One is the violation of probation, and the other is the new law charge, the trespass charge, okay?
Yes.
In both of those cases, you're admitting the violation and you're pleading no contest on the trespass. Is there an adjudication on the trespass?
Yes, Your Honor, it would be adjudication in both cases.
Does it say that?
I believe adjudication.
Yes, it does. It does say that. So on both the cases, you're going to be deemed guilty on of the VOP and the underlying possession of paraphernalia and the trespass. And the sentence that I'm going to give you is actually credit for time served. That's the technical name. But it means you don't have to serve any more jail time, okay? And they're revoking the probation, so no more probation. But you do have some fees and costs they're tacking on. You have 120 days to pay it after today, okay? So, do you understand all that?
yes, sir.
Do you have any questions concerning what we're doing here today? Because again, you don't have a lawyer. I don't want you to go back and say, I didn't realize this was going on.
Yes, sir. All the fees and stuff, I got to pay all of that before 120 days, like everything?
Well, you have to pay it or it goes to collections.
What is that?
That means that you get a judgment against you and they can go after it. You know, they can.
I don't want that.
Yeah, so. You need more than 120 days? If you had 180 days, could you keep it?
Yes, sir.
Okay.
Please.
Well, I'm going to change it.
That's fine, Your
I'm going to change it to 180 days. Okay? So you have 6 months to pay.
Okay, and can I get a copy, what's my, the payment, how much of all I have to pay in general? Because I'm still not understanding how much I have to pay. I don't
Yeah,
know.
do we know how much?
I'm not knowing.
You need that misdemeanor case.
Well, it'd be $270 for the misdemeanor and $520 now with the $100 VOP fee on the VOP.
So what's the total amount?
7, like 7 something, I think.
520 plus the 270? 780? $790.
Okay, $790.
You got 6 months to pay it.
Starting today, and go to
That's
the
right.
clerk.
Pay 120 bucks a month, you're good.
Okay, sir. That's
Okay.
perfect. Yes, sir.
And Your Honor, in just because I wasn't sure it got announced by the court in the 24 MM 3479, the state is not taking action on the failure to appear, just for
Correct.
the
Thank
record.
you
It's
for-
on the plea agreement, but I want to make sure that that's announced so the jail knows.
Very good.
Okay, thank you. Okay, yes, sir.
Okay. Do you have any questions?
No, sir.
Okay. Good luck.
Yes, sir. Thank y'all.
Your Honor, I can appear on Mr. Kane Fuller, my out of custody.
Okay, let's do it.
Your Honor, this is Xavier Kane Fuller, 2023 CF 316. This is the first time up on the VOP. We do have an offer from the state attorney, but I'd like time to discuss it with my client. If we could enter a denial and continue it to the next VOP date.
Can we come back next week? Are you going to be able to discuss it with the defense, the state? October 22nd, is that too
It's
soon?
mine, Fuller, it's yours.
It says it's mine.
Yeah.
Are you going to be able to talk to him tomorrow?
What's that?
Because we're going to be in court on Monday.
No, I don't.
Yeah. Your Honor, we're going to be in court on Monday before court on Tuesday, so I don't know if Ms. Farkas is going to be able to.
Okay,
Yeah,
so he's
I
out of custody,
apologize.
so.
Yes.
Plus, the denial's already been entered on this case.
Oh, I apologize.
So we'll come back on November 14th,
Thank you.
11/14, 9 a.m. Mr. Catalonic, you want to do your cases?
Your Honor, can we ask my case for
Sure.
a few minutes, please?
No, that's fine.
Thank you, sir.
So is anybody here in the gallery that thinks they have a case that's going on today? I know you may be here for somebody else, I don't have to worry about that, but if it's your case, okay, no.
Your Honor, I also apologize for.
No, that's all right.
I just spoke with Mr. Calvert on the phone. His bondsman gave him the wrong court time. He's 5 minutes away. So
Okay.
just letting the court know that we'll handle this.
Okay, we won't we won't pick him up.
Thank you.
Okay, you want to proceed here? Ms. Farkas, you want to go, or what do you want to do? Let's,
I'm ready to go.
okay, Chaplain?
Chaplain?
Your Honor, this is Shaun Chaplain, 2020 CF 292. We have just scheduled this for a sentencing hearing on the VOP on Tuesday afternoon, I think 2:30 p.m. So Mr. Chaplain will be admitting the VOP, but we will be arguing over the sentence at that time. So we'll just continue it to the 10/22 date.
Okay. We'll
We just
continue-
scheduled that, so I apologize.
Okay. We'll continue till 10/22. Very good.
Did you say 9 a.m. or 1:30 for that?
That's in the afternoon, right?
It is, Your Honor.
I can check the time one second.
You're arguing over something in the afternoon.
Your Honor, this is Slater Cole, 24 CF 382 and 24 CF 403. If we can approach on this matter.
You may.
Come on around.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown
So,
Crestview at 107.
Mr. Cole, I know you've been very patient. We're waiting to get you where you can go to the hospital. And I'm sorry that I'm not sorry. I mean, it's not anything I haven't done, but I'm sorry on behalf of the system that you're having to wait around for this. You need to be able to get over there. Your attorney has continued to try to push a little bit on that, and the state actually has offered to try and make a phone call and figure out what we're doing. So as soon as we can get this arranged, we'll have you where you can go over there, okay?
Hey, I appreciate you, Judge.
Okay.
Kessler.
Well,
Thank you,
I'm
Your
sorry
Honor.
you're having to wait so long.
You got any paperwork to take consistent with?
So we'll continue this till 11:14, Madam Clerk.
Okay, hey, I appreciate you, Judge, thank you. Thank you. God bless you. Y'all too, man. Jesus loves y'all, man. Yeah, send it to me, would you?
I will, yeah, I will.
So I can read it. Love y'all, man. I'll be back soon. Love you, Judge. God bless you, Mr. Ketchum. Thank you, Your Honor. God bless you,
Catalina?
man.
Yes, sir.
See y'all. God bless you. Thank you, man. Love you.
Go ahead.
Good morning, Your Honor. I left a message at your office that I was with the circuit judge in the PDA. Thank you.
It's all right.
Parker Jameson Garea, G-A-R-E-A. He's here
Correct.
present, Your Honor. Case number 21 CF 2985, 20 CF 2356, and 20 CF 2010, I believe.
Correct.
Your Honor, if we could leave this case set, I think we're going to leave it, have it resolved by October 22nd, if we can do that.
Okay. So we'll continue all these cases till October 22nd at 9 a.m.
Yes, sir. Thank you.
Okay. Thank you very much. I think that's all you got, Mr. Catalina.
That's all I have, sir. Thank you.
Have a good day. Ms. Farkas?
Yes, Your Honor. This is Daniel Cooey, 2024 CF 281. The state and the defense have reached an agreement, which I've gone over with Mr. Cooey. I'm just going to have him sign it right now.
Very good.
All right, if I may approach, Your Honor. It's fine.
Thank you. Did you announce the agreement?
Yes, Your Honor. 2024 CF 281. There are 3 VOP counts. There was a previous adjudication of guilt on all counts. Count 1 and 2, count 1, 2, and 3, all 3 counts. Mr. Cooey will admit the VOP, 5 months Okaloosa County Jail, credit for all time served, and the time will run concurrently. Revoke and terminate supervision on all 3 counts. And there's a $150 public defender fee. Actually, I'm sorry, I believe it's $100. And he'll have 24 months to pay that from date of release.
State.
That is the state's agreement, Your Honor.
Mr. Cooey, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement. I see those terms are in writing. You've signed them.
Yes,
Just want
sir.
to make sure you've read the plea agreement closely, gone over it in detail with your attorney, had all your legal questions answered.
Yes, sir.
You understand that by entering this will be a final resolution of all these VOPs?
Yes, sir.
But by doing this, you're also waiving the right to go to a hearing.
Right, yes, sir.
So that you can get to that point. And you're doing this freely and voluntarily?
Yes, sir.
Okay, based upon that testimony, the court will accept your plea, being an admission on all 3 of the VOPs. All 3 of them will be identical sentences, 5 months in the Okaloosa County Jail. They'll be served concurrently, so they're served at the same time. You will get credit for all time served. And the court will also revoke and terminate supervision, so you're done with your probation when you get out. $150 public defender fee. You'll have 24 months to pay after you get out of the county jail to pay these before it goes to collections.
Yes,
Okay?
sir.
Any questions?
No, sir.
Okay, thank you.
Your Honor, this is Jeremy Cox, 2022 CF 3028, 2023 CF 2758. The state and the defense have reached an agreement in this case, which I have gone over with Mr. Cox. I'm just going to have him sign it now. And just so the court knows, this agreement will also include a misdemeanor that he has that was part of the basis for the violations in the first place.
May I have the misdemeanor case number, please?
Yes, 24 MM 3143.
Thank
and it's on the agreement as well. If I may, Coach?
Would you announce the terms of the agreement?
Yes, Your Honor. In 2024 MM 3143, there will be an adjudication of guilt in both counts 1 and 2. In count 1, both will also be credit for time served. Count 1, there will be $270 in court costs, $150 public defender fee, and those monetary obligations can be transferred to the felony VOP cases, so he has the entire time of probation to pay those costs. In 23 CF 2758, there was a previous adjudication of guilt, admit VOP, reinstate probation, and modify to complete the remaining term of supervision on drug offender probation. The supervision termination date will remain the same, and that term is going to run concurrent to the 2022 case, and of course the public defender fee. In 22 CF 3028, also a previous adjudication of guilt, admit the VOP, reinstate and modify to complete the remaining term on drug offender probation, and again, the termination date will remain the same.
And before the probation asks me, I'll ask you, what is the curfew on the drug offender probation?
Yes, Your Honor, the curfew is not statutorily required. The state did not ask for a curfew if they would like to.
Actually, I think it is statutorily required. It's automatic.
Oh, sorry. Do you want a curfew on this one?
It's a
Curfew.
drug offender
There's always a
probation.
curfew on.
There's always a curfew on drug offender probation.
Question is, they're flexible. What's the statutory curfew?
It's usually 10 to 7.
It's gotta be 12 hours.
Yeah, 10 to 6, Your Honor, and it can be adjusted for work and school purposes if he goes to school, but work purposes.
Okay, I've added that here.
Oh, just, I don't know if you need to sign it. Okay, sorry.
That's okay.
Thank you. Okay, Mr. Cox, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, the whole truth, nothing but the truth, so help you God?
Yes,
So you
sir.
heard your attorney state the terms of your plea agreement. You can put your hand down. I see you've signed the plea agreement. Have you read the plea agreement, gone over it with your attorney? You had all your legal questions answered? You understand this will be a final resolution of this matter?
Yes, sir.
Waiving the right to go to a trial?
Right.
Okay, you believe this is in your best interest to enter into this plea agreement? You're entering it freely and voluntarily?
Yep.
Based upon that, the court will accept your plea as to the misdemeanor charge of 24 MM 3143 in both counts and adjudication of guilt. Your sentence technically is credit for time served. You got standard court costs. It'll be rolled over into your felony, so you can have longer to pay it. On the 2 felony counts, 2 felony cases, each has a count, 23 CF 2758 and 22 CF 3028. There was a previous adjudication of guilt. You're admitting the VOP. Court will reinstate probation, modify to complete the remaining terms of supervision on drug offender probation. And so you're not extending the probation, you're just changing the nature of it. So it's actually a little more intensive.
Right.
And there'll be a 10 p.m. to 6 a.m. Curfew, adjustable for work purposes. And that's on both of these cases. Again, standard fees and costs that are payable during the term. Any questions?
Yes, sir.
Thank you.
The costs on the misdemeanor case will actually be $300 because there's a driving while license suspended charge.
Counsel, did you hear that?
No, I'm sorry.
The costs for the misdemeanor is actually $300 because there's a driving while license suspended charge.
Thank you. I can put that on.
Ms. Farkas, did your client, is that your client?
Yes, it is. If I could speak with him real briefly before.
Okay.
Okay, thank you.
So
See you later.
we're continuing with your clients, right?
That works for
Okay.
me, Your Honor.
Bring up the next.
Cruz. Your Honor, this is Joshua Cruz, 23 CF 1541. Again, the state and the defense have reached an agreement in this case. I'm just going to have my client sign it. We've gone over it together. Yeah, right there. Did you sign it?
I don't think so.
Yeah.
Did you state the terms of the agreement?
Yes, I'm sorry. There's one count in the felony VOP 2023 CF 1541. There was a previous adjudication of guilt. Mr. Cruz will admit the VOP, 6 months Okaloosa County Jail, credit for all time served, revoke and terminate supervision, public defender fee, and cost of prosecution with 24 months to pay the costs, if I may approach.
Mr. Cruz, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of your plea agreement, and I see you've signed the written plea agreement. Have you gone over it with your attorney?
Yes, sir.
Had all your legal questions answered?
Yes, sir.
You understand that by entering this, you're waiving the right to go to a final hearing. This will be a final resolution of these cases.
Yes, sir.
You believe that's in your best interest?
Yes, sir.
Based upon that, the court will accept your plea agreement here. There'll be an admission to the VOP. The court is sentencing the defendant to 6 months in the Okaloosa County Jail. You will get credit for all time served. The court will revoke and terminate supervision, so you're done with your probation. $150 public defender fee, $100 cost of prosecution. You'll have 24 months to pay it after you get out of jail.
Amen.
Any questions?
No, sir.
Thank you.
Judge and the state will submit a score sheet. That's a felony.
Thank you.
Good luck with everything.
30 days to
He knows. Sorry, Your Honor. Let me get my file. Your Honor, this is Shaun Deere, 2020 CF 1187. I received an offer from the state attorney last night. I'm looking into a bunch of time that I believe Mr. Deere might have in on this case. So if we could continue this case to the 22nd, can we do that? If we could put this on the 22nd, I think that we'll have some answers by then.
Very good. We'll continue this till next week, till the 22nd, 9 a.m.
Thank you.
Hopefully get it resolved.
Delgado.
Your Honor, this is David Delgado, 2022 CF 1653. I believe the state has an announcement in this case.
Your Honor, at this time, the state's going to be withdrawing this violation of probation, and then the defendant will still be on probation, but it will naturally terminate at its termination date.
Very good. No action taken. The state's going to withdraw it. I assume, what does that do? Does that he get out?
Your Honor, I believe he would get out. The new law violation the new law charge that caused the violation has been dismissed. So I'm not aware of anything else that's holding him at the jail, but yes, he does probably need to report to probation, as Officer Keene is shaking her head.
Okay. So just when you get out, report so you can make sure and get back on track on that, okay?
Yes, sir. Thank you.
Okay.
Thank you.
Dorsey?
Dorsey.
Your Honor, this is William Dorsey, 2023 CF 1458. Your Honor, the state and the defense have reached an agreement in this case. I'm just going to have my client sign it. We've been over it together. Okay. talked about it. Your Honor, if I may approach with the agreement.
You may. Thank you. Would you announce the terms?
Yes, Your Honor. There is one misdemeanor VOP count in docket 23 CF 1458. There was a previous adjudication of guilt on this first-degree misdemeanor. Mr. Dorsey will admit the VOP, 11 months, 29 days, Okaloosa County Jail, credit for all time served, revoke and terminate supervision, public defender fee, cost of prosecution, and 24 months to pay from the date of release.
Remember that state's agreement.
Mr. Dorsey, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state that, you can put your hand down, you heard your attorney state the terms of your plea agreement. Those terms are contained in the written plea agreement you've signed. Have you read this thing closely and gone over it in detail with your attorney?
Yes, sir.
Had all your legal questions answered about this plea?
Yes, sir.
You believe it's in your best interest to enter into this plea?
Yes, sir.
And you understand that by entering into this will be a final resolution of this case, waiving the right to go to a trial. Do you understand that?
Yes, sir.
Okay, and you're entering this freely and voluntarily?
Yes, sir.
Nobody coerced you to get you to enter into it?
Nope.
Okay. Very good. Based upon that testimony, state's in agreement on this?
Yes.
Based upon that testimony, the court will accept your plea agreement in 23 CF 1458. Will be an admission of the VOP. The court is sentencing the defendant to 11 months, 29 days in the county jail. You will get credit for all time served. We're going to revoke and terminate supervision. So when you get out, you're done with probation. Okay? $150 public defender fee, $100 cost of prosecution. Have 24 months from the time you get out of jail to pay it before it goes to collections.
Yes,
Okay?
sir.
Any questions?
No, sir.
Thank you.
30 days to appeal.
You have 30 days to appeal. Dunmore.
Your Honor, this is Malcolm Dunmore, 2022 CF 2556. We would like to enter a denial on this VOP so that Mr. Dunmore and I can continue discussing.
Come back on the 22nd or the 14th of November?
November 14th. November 14th, please, Your Honor, we need some time.
Continue this until November 14th. 9 a.m.
Perfect, thank you. All right, I'll come see you, okay? Yes, ma'am. Okay.
Elliott.
Your Honor, this is Walter Elliott, 23 CF 493. The state and the defense have reached an agreement in this case, which I've gone over with Mr. Elliott. I'm just going to have him sign it now. Yes, sir. I'll put the date and I can do it. I know it's hard to write. All right, Your Honor, if I may approach?
You may. Thank you. Would you announce the terms?
Your Honor, there is one VOP count here. There was a previous adjudication of guilt, to the felony VOP. Mr. Elliott will admit the VOP, sentenced to 8 months Okaloosa County Jail, credit for all time served. I'm sorry, I need to put in there that it will revoke and terminate supervision.
You do.
I was remiss in that, I apologize. It's kind of the most important part. So revoke and terminate supervision, public defender fee, and then 24 months to pay those costs.
Very good. Mr. Elliott, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
You heard your attorney, you can put your hand down. You heard your attorney state the terms of your plea agreement. It's in writing on this that you've signed.
Yes.
So just want to make sure if you read this closely, gone over it in detail with your attorney, had all your legal questions answered about this?
Absolutely.
You understand that by entering this will be a final resolution of this case, but you're waiving the right to go to a trial?
Yes.
You believe that's in your best interest?
Yes.
Okay. Based upon that testimony, the court will accept your plea agreement. There was a previous adjudication of guilt on the underlying charges, but you're admitting to the violation of probation. Court's sentencing you to 8 months in the county jail. You will get credit for all time served, but probation is going to be revoked and terminated. So when you get out, you're done with your probation. You do have the always present fees and costs, $100 public defender fee. What about cost of prosecution? You know, she's not getting charged for that?
$100, please, Your Honor.
So yeah, $100 cost of prosecution, $100 public defender fee. You have 24 months after you get out to pay it.
Okay.
You want to try and get it paid by then, because if not, they'll go after your driver's license.
I understand.
So, any questions?
No, sir.
Okay, good luck, sir.
All right, thank you. Take these. Thank you, sir.
You do have 30 days to appeal it if you want to make any changes. Green. Green?
We got,
Oh, that's
Mr. Gates females.
Oh, Mr. Gates, female. Very good.
This is going to be actually reviewed for the court.
Would you pull that mic kind of pointing in towards you,
I'm
Mr.?
going to get organized real quick. I'm going to grab my
Okay.
female files first, Your Honor.
Take your time.
This is Miss Ashley Green before the court, 23 CF 2323. We have a plea agreement to file in her BOP, if I may approach, Your Honor.
You may.
And this made her BOP, Your Honor, so the restitution.
Thank you. Would you announce the terms?
Yes, Your Honor. Ms. Green will be entering a admission to the VOP. She'll be adjudicated guilty, revoke and terminate her probation, sentenced to time served, $100 cost of prosecution, $150 defender fee. She'd ask for 24 months to pay those outstanding fees before they're sent to collections.
Ms. Green, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes.
You heard your attorney state the terms of your plea agreement, and it's contained in this written plea agreement. You just want to make sure you've gone over it with him.
Yes.
You read this, and you had all your legal questions answered by your attorney?
Yes, sir.
You understand you're waiving the right to go to a trial by having this resolution?
Yes, sir.
And this will be a final resolution
Yes.
of your case?
Yes, sir.
And you entering this freely and voluntarily?
Yes, sir.
Based upon that testimony, the court will accept your plea. Was there a previous adjudication of guilt, or were you adjudicating guilty today? You got it?
Previously withhold.
It was previously withhold. So the court is adjudicating the defendant guilty on the underlying charge here today. The court will revoke and terminate probation. You're done with that. And your technical sentence is credit for time served. So you'll be able to get out immediately, assuming there's no other cases
No,
involved.
sir.
And you'll have a $150 public defender fee and a $100 cost of prosecution. You'll have 24 months after you get out
Right.
in order to pay it before it goes to a civil lien, okay?
Okay.
Any questions?
No, sir.
Good luck.
Thank you.
Good luck.
Irafondo?
Yeah, this is going to be Miss Jenny Arando before the court. We have a plea agreement to be filed in her case. It does incorporate a misdemeanor case that I've listed here. That's 24 CT 2213. If I may approach, Your Honor.
You may.
Will be a modification, Your Honor, score sheet's not required there.
Thank you. Would you announce the terms?
Yes, Your Honor. Ms. Arando will be entering an admission in 18 CF 310 and then pleading no contest as charged on 24 CT 2213. She's previously adjudicated guilty in the VOP. We're going to modify and reinstate counts 1 and 3. Ms. Arando will be placed on community control for the next 12 months, followed by the balance of supervision. Count 2, which is misdemeanor, time served. Complete the original requirements, $100 cost of prosecution, $150 defender fee, and then 24 CT 2213, credit for time served. $275 in court costs, $100 public defender fee. She'd asked for 24 months to pay those fees before they're sent to collections.
That is a state's agreement, Your Honor.
Mr. Arando, would you raise your right hand, please? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So, ma'am, you heard your attorney state the terms of your plea agreement, and those same terms are contained in the written plea agreement. Have you read this closely and gone over it in detail with your attorney?
Yes, sir.
You understand that by entering this, you're waiving the right to go to a trial. This will be a final resolution of this case.
Yes, sir.
You believe this is in your best interest to enter into this?
Yes, sir.
So you're entering it freely and voluntarily?
Yes, sir.
Okay. Based upon that testimony, the court will accept your plea. You basically have 4 counts, 2 misdemeanors, 2 felonies.
Yes, sir.
On the misdemeanor counts, that's count 2 and 18 CF 310 and 24 CT 2213. The sentence is technically credit for time served, plus you got some fees and costs which have to be paid. The felony counts, the court's modifying and reinstating probation. That's counts 1 and 3 on the 310 case. And the defendant will be placed on community control for the next 12 months, followed by the balance of supervision. So we're not extending your probation, but for the next 12 months, we're changing it into community control at a higher degree of supervision. I don't like the term community control. I like the term house arrest.
Yes, sir.
Because that's more accurate. No probation, no curfew. Got to be at the house.
Yes, sir.
Okay? You need to pay close attention to this, because if you violate this, they're going to be asking you for jail time.
Yes, sir.
Okay. So any questions regarding any of that?
No, sir.
Okay. Good luck, man.
Thank you. Thanks.
You're welcome.
Humphrey? You know, this is going to be Mr. Ronda Humphrey before the court in 24 CF 665. Yes, this is Mr. Humphrey before the court. He's going to be signing the plea agreement, if I can let him do that, Your Honor. It'll be a misdemeanor plea, so there'll be no score sheet, or is it a plea to misdemeanor? I'll fill in that date for you. Yes, sir. And I will email that attorney as soon as we get done and let him know that you're ready. All right. Maybe you can get something done soon.
You may. Thank you. Would you announce the terms?
Yes, Your Honor. Mr. Humphrey will be entering an admission before the court at 24 CF 665. He'll be adjudicated guilty, he was previously withhold, revoke and terminate probation. It's going to be 45 days in the county jail with credit for all time served. Under the cost of prosecution, $150 offender fee. Mr. Humphrey's asked for 24 months to pay those fees before they're sent to collections.
There you go. State?
That is a state's agreement.
Mr. Humphrey, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state, you can put your hand down. You heard your attorney state the terms of your plea agreement, and I see you've signed the plea agreement that's in writing. So you just want to make sure, have you gone over this with your attorney? Had all your legal questions answered? You understand you're waiving the right to go to a trial. This will be a final adjudication of this matter.
Yes, sir.
You believe that's in your best interest?
Yes, sir.
So you're entering this freely and voluntarily?
Yes, sir.
Very good. Based upon that testimony, the court will accept your plea. There'll be an adjudication of guilt. The court will revoke and terminate probation. You're done with probation. The sentence is 45 days in the county jail, You will get credit for all time served. And of course, you always have the cost of prosecution, the public defender fee. It's a total of $250. You'll have 24 months after you get out of jail in order to pay it before it goes to a civil lien. Okay? Any questions? Okay. You do have 30 days to appeal this if you want to.
You're welcome. That's your call. Yes, sir. I'm gonna see if he can get you down sooner, okay?
Yeah, this is gonna be Mr. Travon Hutchins before the court in 24 CF 356. He also has 24 CF 2294 scheduled for arraignment on November the 14th. At this time, we're gonna enter a denial on 22 CF, make sure I got it right, 356. And where the state did file an information in 24 CF 2294.
Was that on today's docket? did you
It's
say?
on next month's docket. I know the court was
fine.
asking to try and keep that.
Sure.
So we're gonna go ahead and enter a not guilty plea on that as well. And then it should be scheduled for December the 11th on both cases.
Very good. Court will accept the denial on the new violation of community control and the new law charge. Court will enter a not guilty plea and we'll come back on both those on 12/11.
Thank you, Your Honor.
Kinsworthy? Are you ready to go on Carver? Ms. Farkas, after this?
Yes.
After this.
Yeah, this is gonna be Mr. Joseph Kinsworthy before the court. He's on both dockets. This morning's case number is 22 CF 779. Afternoon docket is gonna be 24 CF 1984.
Hold on just a second. Okay, go ahead.
Your Honor, we have a plea agreement to be filed in Mr. Kinsworthy's cases. If I may approach.
You may. Thank you.
Thank you, Your Honor.
Would you announce the plea?
Yes, Your Honor. Mr. Kinsworthy will be admitting the violation before the court in 22 CF 779, pleading no contest as charged in 24 CF 1984. It's going to be adjudicated guilty in all counts. In 22 CF 779, we're going to modify and reinstate the supervision required to complete the original requirements, including the requirement to enroll and complete in the Camp Hope residential program and any aftercare treatment. $100 cost of prosecution, $150 public defender fee. In that case, originally he was allowed no contact with the victim, Ms. Shannon Beeser. After speaking with the state and the victim's case, the state's agreed to modify that to a no violent contact with Ms. Beeser. And then in 24 CF 1984, 24 months of probation concurrent with 22 CF 779, waive the cost of supervision, $967 in court costs, $100 public defender fee, and then again, no violent contact with Ms. Shannon Beeser.
That is the state's agreement, Your Honor. The state is in compliance with Marcy's law, and the score sheet will be submitted in the new case, 24CF1984, and it's not a downward departure.
Thank you. Camp Hope, it's a new one. I haven't heard that.
It's one that he actually was part of as the original program. It's a combat veterans. It's a military-specific program.
Where is it located?
Houston, Texas, Your Honor.
Oh, it's in Houston. That's why I haven't heard about it, probably.
Yes, Your Honor.
Okay.
And
Good program?
Yeah, it changed my life. Like, it's amazing.
And they have actually contacted my office and I think the state attorney's office expressing desire to get Mr. Kinsworthy back into the program, which was a big key to getting him back into the program.
I know it doesn't always seem like it when we kind of go through this assembly line of criminal justice, but we actually do want people to be successful, so I'm glad to hear that you've got access to a good program. Would you please raise your right hand? I just need to ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
I do, Your Honor.
So you heard your attorney state the terms of the plea agreement, and those same terms are in writing that you've signed. Just want to make sure you've read through this, gone over it in detail with your attorney.
Yes, sir, Your Honor.
You understand this will be a final resolution of this case,
Yes, sir.
and you're waiving the right to go to a trial, so you're waiving some constitutional rights to get here.
Yes, sir, Your
I
Honor.
believe that's in your best interest,
Yes, I do, Your
and
Honor.
you're entering this freely and voluntarily.
Yes, sir.
Okay, based upon that testimony, the court will accept your plea agreement here today. There'll be an adjudication of guilt as to both cases in 22 CF 779, that's the VOP. The court will modify and reinstate probation, complete the original term requirements, including the enrollment and completion in Camp Hope residential program and any aftercare. So we're not actually extending on that one. We're just reinstating. And obviously, they always hit you with additional fees and costs. The no contact with Ms. Shannon Beezer is modified to no violent contact, which means you will be allowed contact. So in the new law charge, 24 CF 1984, the court is sentencing you to 24 months probation, concurrent with 22 CF 779, so they'll run together. Waive the cost of supervision. In this case, you got more court costs, public defender fees, and again, you got another no violent contact with Ms. Beezer as well. So, any questions?
No, sir, Your Honor.
Okay, good luck, sir.
Thank you.
That's all I have on the morning, Dr. Young.
All right, Calvert?
This is James Calvert, 22 CF 308, 22 CF 284, and 22 CF 1220.
Okay.
These are all VOPs. I do have the offer from the state attorney. Just this morning, we scheduled it for a sentencing hearing on Tuesday, either 2:30 or 3:30 p.m.
Okay.
So we can continue it to the 22nd, please.
So what's going on the 22nd?
It'll be a sentencing. Mr. Calvert will admit the VOPs, and
Okay, gotcha.
we'll go from there.
Continue this until 10/22, which is next week, and it's in the afternoon, you said?
Yes, Your Honor. It's either 2:30 or 3:30. I can't
Okay,
recall.
Very good. So we'll continue to 10/22.
Are you ready for Medina?
Yes, sir.
We're ready for Medina.
Your Honor, I just have to move my piles of stuff around.
Yes, sir, you may. Don't hurt yourself.
Your Honor, this is Miss Tamisha Robinson, THOMESHA Robinson, and I believe, does the state have an announcement?
Yes. The state is dismissing the violation of probation. Probation will continue and terminate naturally.
Very good. The court will accept the dismissal, so we're back on probation. Does that mean she gets out today?
Yes, Your
Out of
Honor.
jail?
Does she have to,
She needs to get back, I would contact probation immediately when you get, just to reinstate, contact and whatnot.
does she report in Okaloosa County for the initial report today?
Is she where she lives?
She lives in Pensacola.
Or we will transfer her to Pensacola?
I live in Milton.
Okay, well.
And Freeman is
Milton.
my probation officer.
Right, but you.
But that's a different, see, go to where she tells you to go first, and then they'll make sure and coordinate.
Okay.
So when you get out today, you report to the address that Miss Officer Keene's gonna give you, 13 Kelly Avenue, Fort Walton Beach, just long enough to check in, and they'll probably approve you going back to reporting in Milton from now on.
Okay.
But you have to report to her today.
If we don't get out in time, like, cause
You
I
got
got.
plenty of time. It's the morning. You'll get out today.
Okay, they said we weren't leaving till 3 o'clock, so that's why I said that.
You'll get out today.
Is it
Thank
okay to notate on the minute sheet?
I'm sorry?
Is it okay to notate on the minute sheet she may be released?
Yes? Certainly can. No, I appreciate it.
Your Honor, I have nothing else this morning. May I be excused? Thank you.
Thank you. See you this afternoon. More.
Your Honor, Steve Medina with Matthew S. Alford, ALFORD, 24 CF 270. I'm just showing him his amended score sheet, and we have an agreement to resolve his case, Your Honor. Your Honor, I'm approaching with the agreement. I want to make sure I've got a copy. And I apologize, I don't have a copy for probation. It's going to be a revoke and terminate with 6 months jail if the court approves. May I approach, Judge?
You may. Thank you.
Thank you. Your Honor, in this case with Matthew S. Alford in 24 CF 270, he's going to be admitting the violation pursuant to a violation of probation agreement. There will be a revoke and terminate. He was previously adjudicated guilty. 6 months, Okaloosa County Jail with credit for all time served, $100 VOP fee, $150 public defender fees. And I'm sorry, I wanted to ask that he get 6 months upon release prior to monetary obligations going to collections. May I have that?
Sure.
Thank you.
State in agreement, is that the state's
Yes,
agreement?
that's the state's agreement, Your Honor.
Yes, sir.
Okay. Sir, would you please raise your right hand?
Yes, sir.
Do you swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement, and you signed the written plea agreement.
Yes, sir.
You understand that by entering this agreement here today, will be a final resolution of this case?
Yes, sir.
Have you had all your legal questions answered by your attorney about what this means?
Yes, sir.
You understand you're waiving the right to go to a trial?
Yes, sir.
Okay. You believe this is in your best interest?
Yes, sir.
And you did enter this freely and voluntarily? Nobody coerced you, did they?
No, sir.
Okay. Based upon that testimony, the court will accept your plea here today. There'll be an admission of the violation of probation. Court will revoke and terminate probation. Done with that. Okay? You were previously adjudicated guilty. The court's sentencing on this VOP to 6 months in the county jail. You will get credit for all time served. Then, of course, they get the $100 VOP and the $150 PD fee. You'll have 6 months to pay that after you get out.
Yes, sir.
Okay? Any questions?
No, sir.
You got 6 months, 30 days to appeal this, even though you just entered this plea.
Thank you, Your Honor.
Good luck to you.
Yes, sir.
Thank you, Your Honor.
Anthony Allen.
Your Honor, Anthony Allen is before the court for a Nelson hearing, so I'll refrain from further comment until the court decides that issue.
You didn't get my paperwork, did you?
So,
I'm not sure what paperwork. May I just ask him what about?
Sure.
Your Honor, it sounds like Mr. Allen had done his best to communicate with me before today. Was not privy to that, but if we can put him aside, I think we can work up the paperwork for a Phoenix House deal, which will be acceptable to both parties.
Okay.
And that will be in lieu of a Nelson hearing.
Very good.
Could we just have him go back and I'll work on that deal? At worst case, we'll carry him over to 1:30, but
That's fine.
hopefully get it resolved this
Why don't we
morning.
plan on doing
Okay?
that? Sure.
Thank you. Good.
Thank you.
Sorry to hear about your loss.
Frank, we're going to hold Mr. Allen to the record.
Barry Benvenu. Is that how you pronounce that? Benvenu?
I say Benvenu. How do you say it, sir?
That's correct, sir.
Your Honor, Barry B. Benvenu, 22 CF 2296 is before the court. We previously denied the VOP on September 17th. From talking to the jail, from talking to the state attorney's office, if we bring him back on October 22nd at 9 a.m., we may be able to work out his case. We can't work it out today, but the state has suggested we do a short continuance in his case, so.
Okay, court will continue this matter till October 22nd, which is next week. Hopefully you can get some resolution.
Thank you.
Okay, thank you.
Thank you, Your Honor. Your Honor, this is a somewhat similar situation. This is Donnie Bray before the court, B-R-A-Y. Mr. Bray is before the court in, it's docket 36, cases 23 CF 288, 23 CF 787, and 24 CF 587. The state and I discussed this situation. We will ask to continue his case to October 22nd. We will probably work out a bond. He currently has a $2,000 cash or professional. He's having trouble posting that. There are physical issues involved. I've got an outstanding communication with the nurses at the jail, but if we can continue him to October 22nd, we'll either work something out on the case in chief or on a bond.
Very good. So we'll continue this matter till 10/22.
The prosecutor's not going to be today, but by next Tuesday, it's very well.
Yes, you can bond out. Your Honor, in the event he's able to bond out, he will still need to come to court October
just make sure and
22nd
come
at
back.
9 a.m. no matter what. That is your next court date.
Yes.
Okay?
Okay.
Thank
Good.
you.
Thank you.
Thank you.
Your Honor, next is Lee Alvin Brooks, docket 37, 22 CF 1635. Mr. Brooks has a PO recommendation of Phoenix House. I'm going to get him evaluated for Phoenix House right away, but it might take a little while. He successfully completed Keaton, and fairly unusual, Keaton really believes in his progress, but he was still struggling with some, maybe some social services type issues, and if we can continue him, it will take more than a few days to get a Phoenix House evaluation. Can we do a relatively short continuance to November? Are there any dates?
November 14th.
Okay, okay. All right.
Okay, good
And then, and of course, we still have to communicate on this situation with the state attorney's office, but we'll try to work something out.
Okay.
Thank you. Okay?
Thanks.
Yes, sir. Next is Nathaniel Brown. Mr. Brown is number 38 on the docket, and we have an agreement. Thank you. And I just needed to make sure I looked at the score sheet. It's going to be a reinstate and modify, so we don't need a score sheet, but I did want to at least be able to get a So, Your Honor, I was just going over the situation with Mr. Brown that because we've worked out a reinstate and modify, he won't have to go to DOC. But if he were to violate, again, that he very well could be looking at prison, although I don't know what will happen. May I approach with the agreement, Your Honor?
You may.
Oh, yeah, he does need to sign it, Judge. We've been over it, but... And I'm sorry I don't have an extra copy, Mr. Officer King. I got it. Thank you. May I approach, Judge?
You may.
I apologize, the
Thank you.
agreement is a little bit beaten up at this stage.
Dog-eared.
Yes, sir.
It still works.
Yes, sir. Sorry about that.
It's all right.
Your Honor, under the terms of the agreement in 24 CF 1219 and 24 CF 387, Mr. Nathaniel D. Brown will be resolving the VOPs pursuant to an agreement that's before the court. There would be a reinstatement and modify to bars to bed Phoenix House. It's elsewhere stated in the agreement that he admits it. I didn't write it again in the body, but he is admitting the violation. Reinstate and modify to bars to bed Phoenix House is a special condition of probation, $100 VOP fee times 2, and 250 public defender fees. And he has been accepted to Phoenix House, Your Honor. Very quick turnaround.
That's the state's agreement, Your Honor.
Mr. Brown, would you raise your right hand, sir? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So you heard your terms, pretty straightforward.
Yes, sir.
Terms, you can put your hand down. I see that you've signed the written plea agreement. Just want to make sure you had all your legal questions answered by your attorney, because this is final resolution of your VOPs and kind of add some new requirements and whatnot. Have you gone over, had all your questions answered by your attorney?
Yes, sir. The only question is if after I complete Phoenix House, is that a call-in probation or still calling in? If I get early termination, that was my only question.
Your Honor, I advised him that when he finishes Phoenix House, assuming he successfully completes it, he would still be under supervision to the extent there was any remaining probation. This was a 24-month probation deal. Phoenix House is a 12 to 18-month program. Depending on when he goes, he may not have very much probation left, but he's likely to still have some probation, and he will, when he gets out, he'll probably be, at least at that time, supervised in Marion County. If he has any requests to the court to consider, for instance, early termination, he would be able to apply, seek that kind of thing, but especially because there's been a previous violation, he's not entitled to any such relief.
That is a good summary of the answer to your question.
Thank you, Ms. Medina, for the clarity.
Well, he stated it.
All questions are answered, Mr. Judge Kevin.
Okay, very good.
I'm sorry, Judge, I didn't mean to.
No,
I thought it was kind of my job, so.
No, I appreciate it. I was going to say the same thing. You said it extremely well.
Thank you.
So, so you are obviously entering into this freely and voluntarily?
Yes, sir.
Okay. Based upon that, the court will accept your plea. The court will reinstate and modify probation to include an additional requirement of bars to bed to Phoenix House as a special condition of probation.
Thank you.
You must complete the program and any aftercare, and $100 VOP fee times 2 and PD fees. You want to, why don't you put in there, he's got, I don't know how many, 180 days, 24 months or whatever, to pay any fees after?
He'll still be under probation probably
Oh,
for a few
that's right.
months,
That's
so
right.
he technically would still be under
Yep, that's
probation
right.
and supervision at that point.
That's right.
So your money, I'm sorry, Judge.
Yeah, and after that, it goes to collections. Okay. So whatever fees and stuff, you normally have to pay, you have to pay your fees during the term of the probation. So when you get out of Phoenix House, you're
Are
going
you
to have.
talking about the fees you just read?
Yes.
Oh, that's fine.
And
Yeah.
then any money you also owed from
Any
before.
money previously, any
Okay.
fees and costs. They usually are required to be paid by the end of probation.
Before the termination of probation.
All right.
I understand that.
Okay.
That's fair.
Very good. Thank you.
Thank you, Judge
Good luck,
Kevin.
sir.
Thank you, Mr.
Good luck.
Medina.
Take care, sir.
Court.
And Judge, as he's going out, I just
I wanna
want
ask a
to,
question. Could you, yeah, okay.
well, he wasn't here to say